Good morning and welcome to the House Executive Departments and Administration Committee for a work session on House Bills 1458 relative to the licensing of massage, reflexology, structural integration, and Asian bodywork facilities, and House Bill 1469 relative to the licensing and inspections requirements for massage therapy establishments and making an appropriation therefore. Both are dealing with the same subject matter, and it's a very important one that we need to take a look at. Oh, thank you so much. An important one. So we are here spending the time today looking into these details, and the Commission on Human Trafficking and Illicit Massage Businesses will be meeting at 1 o'clock today too. So it's good to have a lot of the same people in one place. With this, I have two documents that I handed out. The first is a look just at House Bill 1469 because Executive Director Dee Juris had pointed out that there were some structural issues with implementation, just because some of these seem to reference to older editions of our statutes. And so this is just places where some redundancy and whatnot has been indicated. This is more in note format for our work as opposed to any sort of final amendment, but it's a good place to start discussions. The other is I went through the existing laws which address sex trafficking. And so I pulled from those. There's actually quite a few that have been passed relatively recently. Effective just over a month ago. Now there's protection from immigration if somebody is a necessary witness to or victim of human trafficking, within the requisites of a warrant, talking about no-knock warrants. There is a process not just for in general when there's human trafficking, but there's a special exemption for no-knock when it's necessary when there's an issue of human trafficking. We've also included people who have been arrested for human trafficking to go without PR bail and to be detained until a hearing if there's a risk to the public. So that's another very important change that was effective at the beginning of the previous year. The trafficking in persons definitions includes the commercial sex acts and abusive law and legal process with victims of human trafficking. We might want to have some discussion about some of that language, but I think we're not going to be zooming in to that extent right now. Then there's a whole statute in trafficking in persons, which is 633:7, and that has felonies for doing this. We actually just increased the penalties for felonies and trafficking children for sexual purposes. That just went into effect, and that one makes it so that the felony is trying to find that time frame, but it's a minimum term of imprisonment of not less than 18 years and a maximum term of not more than life imprisonment if you are sexually trafficking children. Some people don't think that goes far enough, but I'd say that that's a pretty decent place for our law to be at this point. So are a lot of felonies here as well. There's forfeitures, there's the restitution, and in prostitution and related offenses, there's an affirmative defense against prostitution charges if you've been trafficked. So that protects the victims. If you look at federal law as well, there's been a huge effort to recognize that victims are victims. There's actually even a trafficking victim visa, so that victims of trafficking can get a visa, and they may have come here under false pretenses, but they have an opportunity to get that opportunity that they were denied when they came here under false pretenses. And then additionally, within the same general chapter as the human trafficking, we have kidnapping. And to me, if a person is knowingly confining somebody to hold them, to avoid apprehension by law enforcement, and to commit an offense against somebody, and trafficking somebody is an offense against the person. I would like to hear from better legal minds than me as to whether or not this human trafficking constitutes kidnapping. And also criminal restraint is a lower level of this improper detention, where if you knowingly confine another unlawfully, exposing them to a risk of serious bodily injury, I'd say trafficking somebody's body for profit is serious injury. And then the much lower level of false imprisonment is knowingly confining another unlawfully to interfere substantially with his physical movement. You know, when you have people being moved by van up and down the eastern seaboard kept inside a facility for potentially weeks at a time, where they're not able to leave, where their only opportunity is to do what the people who brought them there brought them to do, and then they're moved. Those people aren't just victims of human trafficking. They're at least victims of the false imprisonment. And I think that there's probably an argument for those other felony ones as well. When we look to other statutes, we also have the fraud statutes. I'm not sure if they're written to cover when somebody says that they're offering massage services, but really when you look at some of these dark websites, it's clear that that's not what they're offering. They're pretending to offer legitimate services, but they're actually offering prostitution. I'd say that's fraudulent. If our language of our statutes for fraud need to be strengthened, that might be a very good opportunity for one of these bills. We do have two specific subcases. This is RSA 638:6, deceptive business practices in the fraud statutes. And there's 6-A, which deals in counterfeit recordings, and 6-B, dealing in counterfeit goods. And that may be where dealing in human trafficking may also be another place for fraud. That's something where it would be important for us to consult with others on. And then additionally, a lot of this focus has been on how we can get OPLC to somehow pierce the veil of these criminal multinational organizations in a way that would be able to make this stick, make it so that OPLC can go in and investigate or go in and inspect and have an opportunity to go on the premises of a place that either is licensed or not licensed. Fortunately, if anybody has this list of the existing laws on the second to last page, we have 310:9, complaints and investigations. I did cut out several sections of that so as not to print an extra page. The ones that have the ellipses really have nothing to do with this. It's more it's more malpractice, a doctor not doing their doctoring correctly. And that's not really what we're looking at with the massage. With that, when there's an allegation of a professional misconduct, which would be unlicensed practice, there's the ability for the office or the boards to disclose information acquired in an investigation to law enforcement, to the health licensing agencies or any other jurisdiction. And then in Section 3 of that, notwithstanding any other law to the contrary, the office shall investigate allegations of misconduct by licensees upon its own initiative or upon confirmation that a written complaint alleging misconduct of a licensed or unlicensed individual or entity of a profession regulated under the office should be investigated. With that, and in moving to Section 5, the office is able to carry out investigations with the executive director authorized to conduct inspections of places of business of a profession regulated under the office, which may include entrance into only the portion of a residence where professional equipment is located and does not include home office equipment. Also to issue subpoenas and to serve people who are not licensees or certified individuals. And then finally, within the state law that's here, 310:13 on licensed practice is the one that allows up to a $10,000 per offense penalty within the administrative section of our law for people who are conducting unlicensed practice. So several of these have been changed in recent years. I know that we're up here changing a lot of laws, changing a lot of details on laws, and probably is something where we need to make sure that the full package, the full prosecution package that we have for human trafficking and sex trafficking is well known, not just to those of you who come up to these committees frequently, but to, those guys and girls who are there with their boots on the ground, interfacing with people day in and day out, who may recognize that there's a problem happening, but they're not sure exactly how to address it. So I am going to be asking the commission later on to figure out how we can get that message out to everybody about the tools that already exist. But what we have before us is these two bills on licensing massage. So within the federal statutes, there's also a lot that's been going on there. And we do need to make sure that all of our local partners understand how and when to report this up to the federal government as well, because there are a lot of efforts where they have both the federal and the international agreements in order to try and make sure that it's not just going across state boundaries, but even over national boundaries, they can follow these bad guys and bring justice to them. So I've just said a whole lot about the existing laws. I don't know if anybody wants to say anything yet, or if I want to. Yes, Representative Grota.
Thank you. So I recognize that we have a lot of laws, but there seems to be a hole somewhere because these practices are still happening despite all these laws. And I don't think it's just a matter of education. So I'm hoping that we can have a discussion, because none of us are experts in this area, because we're not the ones who are policing or enacting the laws that we have. So I would like to understand how it is that despite all this, there's still we're missing a piece. We are missing a piece. And I don't know. And I'm hoping that something in these bills can address that, because it's just, I like the analogy that was used in previous testimony that there's different fire hoses to be used, and that this could be a tool, because I think that we don't have enough tools. And maybe that we have the laws, but we don't have enough tools to enact them or to investigate them.
Thank you. And I do think that is why we are all here. We've been adding law after law, changing them, trying to make it so that it can be more effective. And I just feel that we need to be looking at the entire landscape so that anything that we do within this area plays nicely with what we already have as well, and make sure that that's messaged. Representative DeRoy?
Thank you. It seems like we have a lot of laws. There's no doubt about that. I mean, we've got warrants and all kinds of things. And I don't understand. My biggest worry is that we're just adding another layer of bureaucracy onto this. Not that I'm not for it, but anything to help these people and to save these people and to keep them from being abused. But if we have all these laws, I'm anxious to hear from the police why they feel they can't do their job with what we have right now, rather than adding another piece to this. Because maybe it's something in their arena that we need to be looking at. Just my thought.
Thank you. And I think several of these are still very, very new, which is why we've just given them some new tools for their toolkit, and just making sure that those tools are something that they will be able to put into use and implement. I know that in my town, most of these establishments have left, so that's even been after some of these have been enacted. But it's important to see the entire landscape here as well. I do know that one of the specific problems that isn't addressed by the existing laws is around people if they have an establishment and just nobody knowing how you can go forward and make sure that you can have the complaints coming forward and say that this looks like somebody's being trafficked here. We need to look at the fact that people are being held inside these facilities in some level of living condition, which itself is a public health issue, and see how that's something that can sort of dovetail with what we're trying to do here to make sure that the criminals are prosecuted and their victims can be rescued. So with that, we do have these two different bills. One of the ways, I guess, let's look at the specific markup of House Bill 1469, because the original language was written previously, and we've changed some of what we've been doing since then. So right now, this is looking at the massage therapy and establishment regulation. I think, why don't I give everybody just a couple minutes to look that over? I know I delayed us in getting this printout to everybody, but given that it's a work session, let's put some eyes on it, and then I'll turn on my mic in another couple minutes. Sorry, Representative Groda has.
That's okay. Because I think it would be helpful to know that one of the things that was done by the previous OPLC director was to put all the OPLC regulations under RSA 310. And as a result of that, that's those are many of the comments that are here. And I would support those comments so that we're not putting it under the wrong RSA.
Thank you very much. I'll just wait for eyes to come back to me, so don't feel rushed in your reading. Right, I may be cutting you short, but I'll give you just a chance to just finish up reading where your eyes are. So looking at this, there's clearly the case of moving everything into the 310 rules, and those all should be easy changes. Is there any disagreement about the idea of moving any of these? Sorry, Representative Groda?
Yes, I do. Thank you, Chair. I do have one question, and that is it's on page, I'm sorry, on the last page, referring to 328H:9, talks about inspectors. So I just want to, it says that the OPLC shall employ inspectors and authorize them to enter and inspect any establishment licensed under this chapter to determine whether or not the administrative rules for the executive director and the position of the chapter are being observed. So is this the language that's used in other inspections of other facilities? And I just want to make sure that this is, and I'm sure that I just want a confirmation that this language is not is consistent with wording for other inspections and how they're done. Follow up. I just want to make sure that
Yeah.
there isn't some sort of okay, they've inspected it, and then what? Right? What's the next step?
Thank you.
Yeah.
That's a very good question. If you could push the button, thank you.
I thought you might like me on the microphone.
Yes, please.
Do you, I'm so sorry. I was just having a hard time. Where were you, Representative?
I'm on page 6. I'm looking at the mocked up copy, and I'm
Yep.
on the last page.
Oh, where I had struck through the filing the report and that piece there.
Yeah, we took this out. Each inspector shall file a report, and I'm thinking, why would we take that out?
So I think I had struck it because RSA 310 and then the PLC rules govern the process. So we have the PLC 400s, which is fleshing out the rules that flesh out that authority for the process that already that is in the office. So I didn't want to, shall file a report with the executive director of inspection finding results. We already have a process for how inspections are handled within the office. It's laid out really clearly in the PLC 400s. And so I just wanted to, I didn't want to include this process sentence there because it's already covered in 310 and the 400s. Yeah.
Okay, so is it appropriate to make a reference to that rule here?
I don't know that you would want to reference the rule in the statute.
No, I mean the rule number or the fact that the
yeah.
OPLC has the authority to rule. Or this is under the rulemaking, something.
Okay.
I just like to, I mean,
yeah.
to me, this is just hanging out there and,
So you would like to see some language referencing something to the effect of, shall.
something like the standard rules that apply
Yep.
will apply here as well.
Yes. You don't want me to draft that, but I will get an attorney to draft that. Yes.
Okie dokie.
Yep,
Thank
yep.
you.
Thank you very much. I just wanted to make sure Representative Schmidt had a copy of those as well. So thank you. Yes, I think that will be very helpful to know those references, and it is good to not create a separate process when there's already one that's working well.
I'm just making a note.
And as far as discussing just the changes within here, I was trying to break them out by type of comments, just to see if the general move from anything that is now in 310 to reference it only in 310, if there's any problems with just changing those links on any place where the comment says conflicts with RSA 310 or covered in RSA 310. I guess the conflicts at that point, we'll probably want to look at the conflicts separately to see if there's an area where we would want to have different language. So as far as the conflicts on page 2, lines 20 through 23, and then on lines 27 through 30 is where there's the note of the conflicts with RSA 310. The director's still making notes on our previous question to her. I don't want to make her
Okay.
change.
I
her
wanted to
change
make it in
streams.
both sections, right? Because we were talking specifically in the reflexology, so I wanted to make sure I included it in both statutes.
Oh, perfect.
Yep.
Thank you.
So I found the other reference there. If you would like me to speak briefly to that section about the licensing, the renewal portion.
Yes,
So
please.
this is kind of me, this is almost me asking for a favor while we have the whole chapter open. So the current process, and for under 310, all licenses are issued and they're valid for 2 years from the date of issuance. And so it kind of becomes a rolling calendar. Many boards or professions had them, ending on the last day of the month or the first day of their birth month or some set date. But what happened is then you ended up with, we still have the residual where there are boards where 80% of the licenses are in a single month. And so that processing becomes really challenging. So this rolling 2-year basis just makes it better to operationalize. So while we had the chapter open, I proposed that we strike the section about the last day of the birth month and the even numbered year and that piece. And then the fee required is also that's already in 310. So that would be covered there. So that would be lines 20 to 23. And then, yes, 27 to 30 is just to say, let's go with the 2 years from date of issuance.
Okay, so that's just cleanup because we're already dealing with the statute and coming back with another bill in the future would be.
Yes. And it wouldn't impact, right? It would be if it was issued or if it has an expiration date that happens to line up with the statute, it would just continue. So it wouldn't affect the timing. It would just, for people who are getting our new applicants, it would kind of reset the clock on that to be in line with all the other licenses. Yeah.
Thank you, Representative Groda.
And another reason why we made that change was because the boards all had different rules.
Yes.
So it was very chaotic as to whose license expired when.
Correct.
Some of them were every other year. Some of them were on the birth year. I mean, it was just, on the birth month. So everyone has the same, well, this was part of the move from, to have the licenses issued by the office as opposed to the boards. And when they did that, one of the things that became consistent is when the licenses were going to be renewed. So I agree. I think it's good. Thank you for catching that.
Yep. And then the other piece on that exact same line as Representative Groda was just saying on page 3, lines 7 and 8, where I crossed out from the board, the exact same cleanup. The licenses come from the office. Certainly the boards are establishing criteria and rule. So that's just another piece of cleanup there that I caught while we had the chapter open.
Sorry, and you said that those were the two that were right next to each other on page 2.
Page 2, yep. So that was the 2 with the license renewal section. And then on page 3, the from the board. It's the same exact cleanup.
Okay, same.
Yep. And also just while we're having the conversation, the 2-year, some licenses were 1, some were 2, some were 3. The 2-year period is very helpful for budgeting purposes. It's allowed us to be a lot more accurate when we're setting fees because we budget on 2-year cycles. So if we know every license is going to renew in that budget cycle, then it allows us, the math is a lot simpler and our estimates are much better.
Thank you. I always like it when the maths.
Yeah, we're getting there.
Then we have some more covered in RSA. So I think that's most of the covered in 310. Then on page 3, there's a section in the license fees where it's in this bill proposes to reduce the fee for the massage establishment license, but does that go against our general standard where you're paying for the service that you receive from the office and others would be paying more?
Yes, so I think, and this is what I put in the note, I tried to flesh it out, but happy to speak to it or take any questions if more clarity is needed. So the reality is it would have to be if, I think this is contemplating the idea that a facility could be offering services under the cosmetology board and could also be offering massage, and it could be in the same place. And I think this is contemplating that the proposal was to say you shouldn't have to pay. You could pay less because you already have a facility license. I think the reality is because it's governing under 2 different licensing professions, right? They would need to hold 2 different facility licenses, and they would be completely different checklists and inspections. And so I don't know how we would operationalize that. And if we were to do that, then the other licensees would have to pay more because it costs what it costs to employ the inspectors. And so then you would have this disproportionate fee where those who do not have multiple facilities would end up paying a higher fee even in the first instance to make sure that the costs were covered. So
Thank you, Representative Groda.
Yes, and I also want to add that with the rules, with the fees in the rulemaking, I know that the committee that the chair and I are on and Representative Schmidt is very concerned about fees. So we look at those things very carefully. So that's where they belong.
yes, thank you. I appreciate that.
Representative Schmidt.
Thank you, and my apologies for the fact that my car wouldn't start this morning.
I'm glad it got you hear it all.
Right. I'm amazed at my age I can accomplish anything. But in any case, so are we going to wind up without having to, go overboard about it, so that the licensees, the renewals are going to kind of be spread out so that your staff is, the idea of 80% of the licenses being in the same clump is completely bizarre and certainly not at all to be desired. You want to have it so that staff is working steadily and doesn't have, like April 15th, everybody running down to the post office to file their income taxes, except me. I take the extension every year. But anyway, bottom line, so is it going to work out that way, basically without making sure that it's absolutely even? That's maniacal. So do you think will work out that you'll have a steady flow of work for your staff and not these heavy days, so to speak?
I do think that it has been working to even out the workload. The reality is you're always going to have some clustering. You're thinking about graduation, right? Nurses is a huge number of our licensees. Nearly everyone graduates in May. So that's just a busy season no matter what, even with the date of issuance. But it does spread it out a bit. You do still have those pockets, and we will continue to have those pockets for some time as people who are licensed in that old system are renewing. We didn't change the dates necessarily that it was issued. But yes, and I think that this cleanup will just further that process.
Good. I'm glad to hear that.
Yep.
Thank you. And then this next section, there's the part about no town or city shall adopt or enforce a bylaw or ordinance. And then at the top of the next page is the grandfathering. And I think that brings the committee to a discussion too. I mean, it's going to be difficult to implement the grandfathering. Do we look at grandfather only? Do we look at everybody can do these, or do we look at nobody can do those decisions? I think that's one that we're going to have to think about and figure out how we would move forward on that. But I think that technically, I guess, if you can tell us, you had said about the operationalizing the grandfathering, especially because this is put within the licensing statutes. Can you explain some of how that would be a challenge on the grandfathering?
Yeah. Quite frankly, I just don't know how we would do that. How would I know when a license is? I think the purpose was, we're going to say towns and cities have to get rid of their ordinances, but that on page 3, and so that but if somebody has a permit or a license from a municipality, that they can continue to operate under that, but then they would have to renew with the office. And that just seems like an interesting procedure. The qualifications would not be different, so it wouldn't be a renewal. It would be an initial application with my office. And then, the grandfathering of municipal ordinances has nothing to do with OPLC, right? Whether or not they continue to have that permit from the municipalities is not relevant to the state process. It wouldn't alter the fact that somebody would have to do an initial application and start from scratch with the state regardless. So that was the thinking there.
So with that, this is just more about the intersection of having LPLC take on some responsibility around the timing of the local, I'll call them licenses, but the local licenses, and then working that time frame out. So with that, you'd suggest that, I guess the question would be, if we move this way and have a certain date that people need to have these in, should they all be starting on the same day, that as soon as it's required, people need to apply? Or if there's some process where somebody has already been within that, we have a process to give them more time. Representative Grota?
I understand the difficulty of the licensing bit, but we're certainly not trying to take away any legal authority from the municipalities. So I think that we should change this to say somehow, I don't know what that looks like, that licensing issued by municipalities become null and void after a certain day. Let's say, if this is taking effect in July, let's say July 1, right? And that from there they have to get their license from OPLC. But that this change in licensing authority does not negate the ordinance authority regarding how a town legally manages these businesses. Something like that.
So
right?
I think as originally presented, the language on page 3, line 26 and 27 says they cannot adopt or enforce a bylaw or ordinance for licensure of massage establishments. So that says, all right, get out of here, municipality. The state's got it. Don't regulate this at all. So that's a policy decision. My proposal was why would we prevent them if a municipality would like to require them to get a permit in addition to their state licensure, but that's a policy decision. Yeah. So I don't want to project that you should or shouldn't, but I think we had several conversations, and I believe there are members behind me that also were in favor of that strike through. Where's Pamela? Sorry. I did discuss it with the coalition, and I think that actually may have been a recommendation from a few national groups that you don't want to limit a municipality's authority to do that regulation.
Representative Grota?
And I
That's right.
don't
You
know
don't
if there's
want to.
anybody in the group from a municipality. I believe you may be. I'm not sure. I'm pointing to this man with a tie. But, oh, you're not. Okay, I just thought that we should have some feedback from the municipalities that testified on the bill to have their, to at least hear their voice.
Yes.
Yes. And Representative Bailey?
Yeah, I have a couple of concerns. I've spent a certain amount of time with licensing, and there's usually some kind of board that's saying what you need to be an expert in this thing and to be licensed. And I don't see anything like that here. And quite the opposite. It says you do not need to know anything about being a masseuse to be the manager of this place and to be licensed. It's enough that you hire someone who's a masseuse. And I don't see why we even have this then if there's no rules or no expertise we're trying to enforce, or we're just trying to impose a sort of system on these people, but there's no expertise being enforced.
I believe this section is in the same section that's under the massage therapist board, correct? This
Yeah,
section
so the
here?
board would
Except you
establish the
don't need to be
criteria.
one of those to
Yes.
be the manager of this establishment.
Yes,
This
correct.
licensed establishment. So there's a problem there.
I believe, do we do that in cosmetology, where you can own a cosmetology but not be licensed?
You can, yes. So you
Yes.
have to have a licensed manager, but you can own a business that provides services that require a license without yourself holding a license. Yes.
Representative DeRay?
But does that leave an opening? I mean, these individuals are crafty individuals anyway. They've been doing this a lot, and they're finding every way to keep themselves open without having to abide by the law. Wouldn't that be, if we're going to do this, wouldn't that just be an extra little thing in there to deter them if they don't have that expertise? Because we know what we're doing. We know what this is for, right?
Yes, I do think that there's one moment, and I do think that there's the question of, do we do this all under massage licensing, or do we look at this and say, if you're going to run one of these, as long as it's not a sole proprietor, where you're the only person there, you're not hiring anybody, and you're not renting space to anybody else, do you need to then have a license where we're pretty much trying to make sure that these aren't people with criminal histories and other things running this? Do you then have an operator license where you have your tax ID, your background check, a functional understanding of the English language, so you can actually interact with the police and the licensing boards? And if we do that, I think that that's more around running the operation. So that's more agnostic as to whether somebody is licensed or not. That either could be for somebody who is licensed and running a shop, or if you just do that, even if you don't have a license, if you're running a multi-professional shop, to require that. And that I think is an approach that to dig into for the bill that I introduced, that I'm looking at as a scalpel, as opposed to the big inspection one as well, because I think this is large enough that it's important to be able to evaluate two different approaches to it. But yes, I do recognize that trying to follow the same path that they've been working around presents challenges. Representative Bailey?
I'm seeing this for the fourth or fifth time. And nothing alleviates my prior complaints that this is not licensing and expertise. It's providing a Fourth Amendment workaround. That the police can just go in there anytime they want because it's the license thing. It's not because they're enforcing an expertise, or it's just a workaround for the Fourth Amendment. And I don't think that's legitimate.
So we've actually already provided for that in RSA 595-8:2. That's the one on the requisites for a warrant, and there's no-knock warrants that you can get into human trafficking cases. So the idea of using this as another avenue to get in the door, especially when OPLC is already able to go and inspect either licensed practice or those who are doing that, I agree. Since there's already approaches to be able to get in the door, I'm not sure. I'm also conflicted as to the utility of that approach.
Were you to go back in the no-knock warrant, you'll find that I was a co-sponsor. And I very much objected to their final version, which was, there'll be no no-knock warrants unless we really need to. It's like, in my youth, I was a mailman, and under the contract we were operating under, the managers could not compel you to do certain things unless it was an emergency. And who gets to decide if it's an emergency? Oh, the managers.
Mm-hmm.
So this is just nonsense.
Representative Gerda?
So this is we license a lot of establishments. It's not just massage. It would be a cosmetology is licensed, because everyone that does, and cosmetology involves hair, face, nails, because those things also are areas where someone can, and there are certain hygienic and public safety issues that are affiliated with those crafts, with those trades. And if you look at all the businesses that we license, this is essentially a business that is also, it makes complete sense to put it in there with all the other ones. The fact that this is being used, unfortunately, right? There's two components of it. There's the inspection of the facility to make sure that, yes, the massage therapists are licensed, that that there's hygienic procedures being used. Those are all important. And the secondary component of it is that it allows the OPLC inspectors, just like they can go in any other facility, to go and check to see if everyone's licensed. And that's where, if there is an issue, it's up to them as to if it's something like, okay, there's 3 massage therapists and one of them has a license that expired. That's a whole different kind of reprimand, let's say, that would be used as if nobody's licensed and it's being used illicitly. That's a whole different thing. So that we're all jumping to the conclusion that this is being used for that, but it's also being used for other things as well. And so to me, this is just a natural extension of what we do with public safety. Does that make sense?
Representative Bailey.
Well, my concern about the Fourth Amendment workaround is not just a fever dream. I mean, over 4 or 5 or 6 years that this bill has been coming forward, the police who have come in are pretty explicit about what they want to do. And it's a Fourth Amendment workaround. And they don't give a damn about massage licensing. They want us to go in there and toss the place.
Careful with the attributions of how people,
Yeah.
people's intention.
They have explicitly said that's what they want.
I'm sorry. As a sponsor of all the other bills that have been put forth, I think that they did not say that, and that OPLC inspectors are the first people to go in there. It's not like I can go in there anytime, because the police can still not go in there anytime just because, unless they have cause. These are public, right?
Public accommodations.
Yep.
There's a workaround, unless they have cause. Well,
Microphone. Yes. Yes. Sorry, Representative Schmidt was talking about the cause and this being the cause.
Do you
So-
mind, Madam Chair, if
Yes.
I just speak quickly? So in the bill as introduced and then still retained within my comments, I'm on page 5. It exists earlier in the bill as well. There's a bold section towards the middle, line 23. Nothing in this chapter shall require a residential care or health facility licensed to RSA 151(2) to attain an establishment license. So the reality is there are facilities licenses of healthcare agencies, child care, adult daycare, that are regulated by the Department of Health and Human Services. So the OPLC is not specifically regulating those, but there are a lot more establishments that are licensed and inspected that are outside of the umbrella of OPLC. So those healthcare facilities are licensed by the state. I would imagine things of that nature are probably going to the HHS committee, but there are a number of facilities that are licensed. It's more limited in the OPLC licensing space. There are not as many, but there are a number that are regulated. So 151(2) is kind of the reference to see some of those other establishments as well, just for that broader context. So that anything beyond saying that is outside of my expertise and outside of my realm, but just worth noting.
No, thank you very much. And that is the hospital licensing. So a lot of that doesn't cover doctors' offices. It doesn't cover chiropractic offices who would offer massage as well. Because linking it to the healthcare facilities, which is the hospital license, your chiropractor who offers massage therapy would need to get this facility's license as well, the way that this bill is written currently. So if we're not intending to include chiropractic offices and other wellness offices or those that are licensed by DHHS, it'd be helpful if somebody could have some language for that. Representative Grota?
Sorry, I forgot my. Yeah, I'll look into that, but I do understand with the intent.
And then looking further at this section, the other is another very important note was the request to change the effective date so that it would line up with the next budget cycle. That is one where this is a pretty significant cost, and I will ask about some of that cost details as well. But could you tell us a little bit more about why July 1st would work so much better than January 1st?
Yes, thank you. And to be clear, this is a request. This is not just a technical change. This is a request by me. Should this legislation move forward, I think as you were discussing earlier, right? These fees are set kind of on a 2-year estimate. So being able to line it up with the budget year would just allow us to set fees more appropriately and be a bit more specific on target with that estimate, as we would set the fees for the establishment license, but then we would also have to look at what is the cost to the individual massage therapist. Yep.
Thank you. Representative Schmidt?
Thank you, Madam Chair. So one of the things that occurs to me, and Representative Bailey was speaking to this a while back, about the idea that you can have an owner, for example, who's not a practitioner, and that would not be illegal. But do we have a situation where the shop is open and there's nobody there that has training in the profession that's being offered to the public? Because to the degree you got, if the owner is not a practitioner or not an expert, not competent, then if he or she is the only one there that day, then you got work being performed on patients with nobody that knows what they're doing. And we saw it a couple of years ago that some salons were offering free treatments as inducement to bring people in, of course. And it turns out they were using people who were not trained. They were cashiers or something like that, and they would be doing things to people that required some expertise. And the idea of the idea behind the abuse was they got work out of people who were not qualified, but then the customers are at the mercy of somebody who perhaps has only seen things done and has no actual training. So do we have some kind of requirement that the shop cannot open and function if there's nobody on the premises that is a trained and licensed person?
So with that, I would actually call on some of my experience. In high school, I worked at a gym that had a whole massage area. We had the doors open to book appointments, change appointments, make appointments, but they didn't have me going back there and giving massages. There's reasons to have people in the facility and still have the door open or the phones on, even when there's nobody there who can practice the profession. And having somebody else do that, I believe, would fall under that unlicensed practice, or even though that's not for pay, because they're being held out as somebody who would perform that would be unlicensed practice, correct?
Yes. Yep. So page 3, lines 12 to 15 would be the most on point to the specific thing. The executive director may issue an establishment license to an applicant who does not hold a personal massage therapist license, provided that the owner employs a licensed massage therapist as a manager. So it doesn't say they have to be there every time the door is open, but they do have to have a licensed manager. And then this paragraph shall not authorize such owner to personally engage in massage therapy. So having an establishment license does not authorize that practice, or would not for anyone else.
Thank you. So looking at this section, there's some areas that just for technical reasons, or one's cleaning up on the local control issue and potentially lining this up with the budget cycle, are things for us to take under consideration. Additionally, I'd like to better understand what the cost of this is to licensees. We operate on a fee-funded system. So if we were to take this, 700, let's call it maybe $600,000 a year, biennium, how many do you know about how many licensed massage therapists we have and how much per person that $600,000 a biennium would break up to be? Excuse me. Sorry.
Where are you seeing 600,000?
So if you go to the fiscal note, actually it's, if you go to the expenditures, there's that first year to get it up, which is the 403. Then the fiscal 28 is the 316, fiscal 29 is the 326. Since they're on 2-year license cycles and it's a biennium,
I see what you
looking at
did.
the 600 by adding those together.
So the current, I'm looking at the OPLC annual report, which anyone can access on our website for 2025. So for massage specifically, the revenue, so that means license fees that were created, I will round it to $120,000 for 2025. It's 119,661.01 if you'd like to be very precise. I round to 200,000, or no, 120,000. Excuse me. The expenditures, so the amount that was the money was spent was 130,1462, so roughly $130,000 for the 1 year. So again, rough round numbers, you would about double that. So you'd be looking around $260,000 over the biennium. So if you had, so it would be a tripling of the costs associated with this board. So
And what's the current cost?
the expenditures for fiscal year 25, just the 1 year was $130,000.
But how many therapists?
Oh, sorry. That's a different page. Let me scroll there. 2,091 active licensees at the time of reporting 2025.
So that 2,000 licensees with $250,000 a biennium is about $125 a piece.
Yes, and the fees currently set, that's in the PLC 1000s as referenced earlier, it's $121. So we're pretty close there. That's pretty good mathing on our end.
And you're saying that with this, then depending on how it's distributed, whether it's to massage therapists or another license category, you're looking at tripling. So you're talking about $360 a biennium,
So it would
roughly.
the math gets more complex, right? So then you would have you would have an establishment license that would have a fee, so that would be a separate type of license. And then we do charge for the actual inspection. Currently, cosmetology inspections are $100. We would probably look at parity with that. So we would probably look at $100. So then I would need to have some assessment. How many establishments are there times 100, subtract that, then try to estimate. That would be, a very ballpark, but then how many of those it would be a massage establishment license, how many would we think we would have, and then we would have to do the math. But it would be a significant cost increase.
So if we were to take this and say that if it was equally distributed to the massage therapist, let's just throw $500 on that. If there's an average of 4 massage therapists per facility we're looking at $2,000 for I'm not out of the ballpark, even though it's completely rough numbers.
Yeah, I don't know if anyone in the audience has a rough number of how many massage establishments we have in the state. I don't know if that's a number we have.
Excuse
It's
me,
looking
but it
like
would
maybe
have to
no.
be massage establishments that have more than one.
More than
person,
one, yes.
right? Because the whole purpose was not to inspect someone who has a sole
Right.
business, right?
Not to create a new inspection for people with a sole
Right,
business.
right.
Yes.
Right. Yeah, so we would have to do some work. I would probably look at employment security potentially, maybe Department of Labor, maybe Secretary of State's office if it's a business that's registered with them to try to get some round number. And so then a new fee would be established for the facility license. And so then we would kind of divide the math and say, I would say probably a facility would be more expensive because a facility is the reason there has to be an inspection, which is why the cost is going up. But it would be very likely that we would either have a very, very high establishment license or the actual massage therapist license fees would also have to go up to cover those costs.
I'm thinking if half of them were sole proprietors and then the other half was 4 people per, then you take those numbers and you're looking at something like $4,000 for the establishment license. Obviously we'd have, because if you take that amount, it was $500 per person if it was individual. If you were to divide that into 1 and 4, if it was 4 people per the facility, this was the increase. And then if it's only half as much of that, it needs to double again. So we can run through a couple different scenarios, but I would say that is it not out of the ballpark to say that it would be in the low thousands of dollars, most likely very low?
So if we're at $600,000 is the fiscal impact over the biennium, and that's fairly conservative. That's only 3 new staff, one of which is named in this thing, and then 2 inspectors and vehicles. So that doesn't account for any other increased costs that just naturally come with government. So I guess if you say there's a 1,000 massage establishments at $600, that I don't know if there are 1,000 in the state that would be regulated. That is kind of the question is what does that number look like? I'm sure. Maybe the commission could
get an idea of that.
could get an idea of what that number would be, because that would be how we would determine.
Thank you. I think that that's a very good question to figure out how many. Okay. And then, that's a huge cost.
It's very personnel, salaries and benefits it's very expensive. Yes.
Representative DeRoy?
This must be self-funding. It would have to be. I
Yes.
can't imagine the taxpayers wanting to kick in. So whatever it is.
No, we don't. We have no tax dollars in the OPLC. It's all fees. Yep.
Representative Sellers?
Thank you, Madam Chair. So I'm trying to make sure on the funding part and the number of personnel needed. Don't you have inspectors already?
We do. Currently have one cosmetology inspector. I do have a position that was recently vacated, so there would be 2 people. But there are about 3,000 cosmetology shops in the state, so I have 2 inspectors for 3,000 there. So we had estimated it being on par with that, to just say, look, I actually have 3 cosmetology positions. 1 is defunded in the current fiscal environment. So I have a chief and 2. I have 1 person doing it. We're doing the best that we can. Looking to onboard another person. Those are, and then I have pharmacy inspectors, who are pharmacists and farm techs and have that expertise. So I would not have pharmacists out doing massage establishment inspections presently. So we very limited actual staff.
Yeah, thank you, Madam Chair. So you're throwing a lot of numbers out at me.
Yes, I apologize.
And I don't know each group here in cosmetology
Yep.
versus the massage. Technically, you're saying these are 2 different groups, and you have 3,000 cosmetology, and then we have what we come up with, 2,091 massages.
No, so I'm sorry. That 2,000 is the number of massage therapists.
Right. Okay.
So not all of them would have their own facility. So it would certainly be fewer than 2,000
So-
establishments.
If I may.
Yes.
So you could go to one facility and license 3 or 4 massage therapists at all in one inspection? Am I assuming right?
The inspection would only be for the facility. So there's
Okay.
no inspection of a person.
So licensing then?
So the licensing would be absorbed with existing staff. So the cost is associated with the salaries, the benefits, and the vehicle for the inspectors who are driving to the actual facility.
One more question.
Yes.
I'm trying to figure out, so how many locations are there, massage locations are there? Because now I don't want anything to do with therapists. Since we're doing inspection and you want inspectors,
Yep.
I'm trying to find out how many locations.
Yes, and that is we were just discussing earlier. I do not have that number. We don't currently regulate it, so I don't know. So that's what I was saying. The commission might be good for the commission to get an estimate.
So how would I know how many staff to give you then?
It's a fair question. We have to make an estimate within 5 days of receiving the request, so we do the best we can.
Thank you. And since, yes, Representative Schmidt?
Thank you. But my understanding is that never having had a massage myself, but I know that therapeutic massage is a very valuable service. For example, for people who are bedridden at home, they're not going to be coming into any place because they're bedridden. But they do need massages to protect from bed sores and all kinds of bad things that happen when you can't get out of bed. And those of us who are, still ambulatory and so forth, and never think about the fact that there are people out there who just are stuck. And they're not going to be going to a massage establishment either. And sometimes I think some people, like, for example, a therapist will rent a hotel room where they can have a bed and somebody who is not bedridden but can't go 50 or 100 miles to an establishment. They need that service, and it has to be clean. and sanitary and so forth, the way a hotel or motel is sanitized on a regular basis. So this service is absolutely vital for good health. But to respond to your question, Representative Saunders, there's no establishment involved sometimes because it's not at home, and it's not in a licensed establishment, but it's still massaged under sanitary conditions and so forth by a skilled, trained technician. If I can call him a technician.
It's an interesting point, Representative. I don't know that scenario, kind of an in-home care, is contemplated by the current language. It might be worth looking into, but I don't know if you would be looking at unintended consequences. The more exemptions that you put into it, that would certainly be a policy decision. But it's an interesting question of could you do, if you were a massage therapist, you were not a sole proprietor, so you were employed by somebody, could you perform massage in somebody's home? I don't, it's not something I'd considered within this proposed language.
I think that would bring so many different questions that would deserve its own bill if we wanted to look at anything related to that.
Well, it's just that we ought to at least, contemplate some of these things. Maybe things are not going to be regulated or whatever. But I mean, I'm pretty sure that some therapists are going into people's homes. They've got their fold-up table and so forth and so on, and they're performing it there because that person can't get out of their own home, and they need that service.
I believe that would fall under the unlicensed practice, correct? If somebody wasn't licensed and they were going into somebody's home doing massage for that. And as far as the human trafficking,
I'm not thinking about unlicensed practice, but just briefly, let's consider people who need infusions.
so this is really outside of the scope of it. I've kept you guys into the lunchtime because it's 12:30 already, 12:20, and I wanted to keep talking through a bit of this. We do have the Commission on Trafficking. If we want to talk about some more of this after that, we can. But I think you're getting outside of the sex
I'm
trafficking
respectful
part of it.
of the fact that I've delayed things by being late, and you have to. You're the manager here, so you have to factor all this in. Thank you for your time.
Thank you. And then my question is this one with the structured in process of the inspections. I know that there's going to be a lot of people who are very, very committed to moving forward on that process. I have the separate bill 1458. If we were to consider something where we're looking at somebody who's an operator of a multi-licensed person, facility where all you're doing is a license that's the tax ID, their background check, those basic requirements to be able to have a decent expectation that the person's not a criminal and that you actually know who they are so you can track them down. Is that going to be the same kind of cost, or is that going to be just, the cost of just putting in another basic license?
So you're thinking about, in addition to the facility itself being licensed, you would need a license to actually own the facility?
No, I'm thinking about leaving the facility's license to its own separate part in 1469 and looking at an
Okay.
approach in 1458 where you are simply to operate a massage establishment where you employ other people or rent space to another person, that one you need you need a license to operate that. You have a background check, you have a tax ID that proves who you are.
Okay.
But it doesn't go beyond that. And you use the basic OPLC right of inspection in order to do spot checks if there is a complaint or a suspicion.
So the individual, it would be creating another license for an individual to hold. Those costs, I mean, the office is not infinitely exorbitant in terms of at some point we won't be able to continue to say, yes, we can take a new license with no staff or no cost increase. But I would say one additional license within this space could likely be absorbed within existing staffing, or potentially a very, yes, I think it could be absorbed. I mean, this is a challenging environment. I don't want to absorb any more work right now with my current staffing levels, but I would say within appropriations, that cost could be absorbed. So it would just be the processing of an application, right? It doesn't involve the routine inspections of the actual place. I will say that that deals with the individual person. It does not address the sanitation and the facilities piece of it. So that maybe it gets at half of the problem potentially if I'm speculating about the policy considerations. Yeah.
Thank you. Representative Groda?
And if we went this way, there would be inspections because there are going to be people that are going to call and say, so I don't think that you can just say it's an administrative function.
Yes, I could say, yeah, I would anticipate, because of the anecdotal evidence that there are illicit actors in this space, that we would potentially be looking at more complaints. And so on that enforcement side. So for the actual processing of the application that could be absorbed, the staffing needed to follow up on those complaints would be in the enforcement side of the house. And some of that would just be, we'd have to see when we got there. I don't know what, that's an incalculable number.
Are people able to make those complaints today, even without the facility's license, where they say that they got a massage from somebody and it was filthy?
If it was a licensed person, and so a complaint, it would be that somebody violated a statute or a rule, which includes the code of conduct. So I don't have the massage, all of the regs in front of me, but if there are requirements for sanitary provision of a space or whatever that would look like, somebody could file a complaint against a licensee. If it was a person who was not licensed, then it would be an unlicensed practice complaint. That would go to the Department of Justice presently.
Okay, thank
Yeah.
you. Representative Groda?
Yes. So so that if somebody files a complaint, though, they need the name of the person,
That's true. Yes.
right?
We can't follow up on a licensee. We don't know who it is. Yeah.
Correct. Okay.
But if you have a complaint that you had a massage at 123 Main Street and you walked in and the place was crawling with cockroaches and they said they were a licensed person, but you turned around and walked out, is there still an opportunity based on the potential unlicensed practice? Or, you know what? I think I'm splitting hairs.
We
I'm
would
not
need a
gonna
name
hold
of a
anybody
person,
back.
right? I mean, this is the same. I would say DOJ's testimony is consistent, right? We need to know at least who it is to try to contact them. Yeah.
Okay. Okay. Thank you.
Jeff,
Yes.
do we know how many complaints have actually come in on all of these? Oh, somebody's got numbers. I love numbers.
I wouldn't be able to specify what type of complaint had come in, but I can tell you the number of massage complaints that were received if I can open the internet. Again, this is all, we do produce an annual report every year. So this is on our website. In 2025, there were 13 complaints filed relating to the Massage Therapy Board.
Thank you. Are there other questions for the executive director? Thank you so much for offering that with us.
Thank you.
I don't know if Chief Fioli, if you could answer if I had some questions about just what information specifically you were interested in for facilities owners. Oh, could you push the button so the light is on? Thank you.
Thank you. For the committee, my name is George Fioli. I'm the Chief of Police in Derry. I also speak on behalf on this matter of the New Hampshire Association of Chiefs of Police. Now, before you get into questions,
Okay.
thank you for developing and publishing this list of RSAs that refer to these types of offenses. But let me say that most of the offenses listed require a victim. And without a victim, there is no enforcement. So you've listed a lot of criminal statutes here that are very helpful, that we know exist in current law. But without a victim, there is no enforcement for those statutes. The Chiefs of Police Association and me, personally, speaking from experience, I had 6 of these illicit massage businesses. I'm not seeking to regulate any legitimate massage business. We seek to focus on illicit massage businesses. We had 6 of them in Derry operating last year. We closed almost all of them. One quickly opened up again after in the same location that we had shut down. The operators of that business quickly opened up in Bow, New Hampshire. So we seek, because there is no state regulation presently, we seek to stop these businesses from popping up like candy out of a Pez dispenser, for lack of a better term. They willy-nilly move around the state to a community where they see no resistance to their operation. We spoke earlier about some communities having ordinances and instituted ordinances to try to regulate these facilities. Those efforts are born strictly out of frustration that the state doesn't regulate presently. I would have no objection to recommending to my town council that they abandon our town ordinance that we do have if the state was to institute 1469 or some similar legislation. With respect to the Fourth Amendment claims that were raised earlier, from the police department's perspective, and I speak for the state, we're not looking to violate anybody's Fourth Amendment rights. We're not looking for a Fourth Amendment workaround. We just simply want regulation to stop these illicit massage businesses from opening up willy-nilly in our communities. I don't think I can say it more plainly than that. I'm happy to answer any questions you might have.
Thank you. I know that one of the big challenges is having people that have a history, have an existing criminal history, opening up these facilities in town or attempting to do so. And I just want to have a good understanding of specifically what you would need in one of these operators, either in the 1469 scheme or a different scheme, so that you could have the information that you needed, so that you would have the information of a person who may or may not be doing something criminal.
Thank you for that question. We have found, in our experience in Derry, and bear in mind there are rules and regulations with respect to law enforcement conducting criminal inquiries on individuals. Absent a valid investigation, we just can't willy-nilly run a criminal background check on somebody. But there is a fair amount of open source intelligence out there when you Google someone's name, and you'll get a return in a lot of cases, and we did in several instances in Derry of individuals opening up these illicit massage businesses in Derry that had been convicted in other states of prostitution-related offenses with respect to operating similar businesses in those states. We were able to use that in our case because we had an ordinance that spoke to that specific instance and that violation of our ordinance. There well could be other practitioners operating in Derry that we did not do an inquiry on because we have no basis for that inquiry, that had criminal record checks or criminal records that didn't exist in the open source intelligence world. They may be in a criminal database someplace that we can't find when we do a simple Google search. We just happened to get lucky with a couple of them that we were able to turn up newspaper articles, news articles that refer to their convictions.
So if we're designing the system of what somebody needs in order to be licensed to run one of these
I would recommend a
facilities,
valid criminal record check.
so a state criminal record check, not needing an FBI criminal record check?
Would it be typically any other criminal record check, the requirements to perform a criminal record check would be met with this statute as well as the same as any others.
Okay. This committee has dealt with setting FBI background checks and the language for that, and that's been a larger headache than it should be. So if we just started with a state background check, would that be an adequate place to start?
Typically, criminal record checks are fingerprint based or fingerprint supported. So a candidate would typically submit to a fingerprint card, and that's submitted to the New Hampshire State Police for criminal record check.
Okay, so if a state police criminal record check works. then-
Yes, that would work fine.
Perfect. I just want to make sure that we'd be putting the right tools in there. Then also having a tax ID or social security number verified for the identity of the person. Do you think that the fingerprint is sufficient on that?
For the identity of the person?
Yes.
I do.
Okay. But they probably should provide the tax ID or social security too, because if those don't match, then we have another problem, correct?
We do.
Okay.
Yes.
And then a functional understanding of the English language so that they can interact with the OPLC and police.
Absolutely required. We did run into quite a bit of experience where the language barrier existed, and these folks that we were dealing with had no English language skill at all.
Thank
And
you.
My staff doesn't have Mandarin or other skills, so I had to rely on interpreters.
Thank you. I mean, obviously, we want to be mindful of people who are trying and working on their English, but you need to be able to have at least certain levels of discussion. Representative Sellers, you have a question?
Yeah, thank you, Madam Chair. I believe there's an app for that.
There is.
Anyhow, I'm concerned about background checks and fingerprinting. All right, because let's say 95% of the people are honest, law-abiding people. There's no issue. Technically, if you do these background checks or fingerprinting, nothing comes up on them. What happens to that data once you get it?
I'm not sure I understand the question. What happens to what data?
Well, you
There is
You
nothing.
did
There is no
I
data
wanna-
because it returns a no hit. We call it a no hit. There's no record.
okay? So let me finish if I may. So I want to open a massage parlor, so I have to give you my fingerprints and all my information. So then you do a background check on me. What happens to all that information I gave you in my fingerprints? Because it came back nothing.
It would stay with the applicant file. Just the same. This is no different than I'm on the board of directors at the local Boys and Girls Club. We have volunteers that want to work in the Boys Club. They have to submit to and pass a criminal record inquiry. Same as folks want to volunteer in our schools. They have to submit to the same kind of criminal record inquiry. We're not looking for anything different than that.
Okay, so, and with that, the disqualifying offenses, we'd have prostitution, we'd have human trafficking. What other sorts of disqualifying conditions? Or if we can just set that in rules, that probably makes sense to set that in.
Yeah,
rules,
I think
correct?
we could get into the nitty gritty on that at later time.
Okay. And the biggest intention is just to make sure that you don't have people who are operating these facilities who are already known criminals.
Correct.
And that it's more difficult for the criminal element to operate these facilities that pretend to be legitimate businesses in the state.
Yes.
Okay. Thank you. Representative Schmidt?
Thank you, Madam Chair. So if my experience with this, which goes back, I don't know, 6 or 7 years anyway, we've been dealing with this situation of an enterprise that purports to be legitimate, but is completely illegitimate in terms of what they're actually doing. They're not therapeutic massage therapists at all. They don't have training. They don't have licenses and so forth. And and very often the manager is only kind of pro forma. The syndicate down in Flushing is running these entities all over, wherever they are, and they are the entrepreneur. Is that not the case?
That is absolutely the case.
Right. And so criminal background check may not come up with anything on the manager who purports to be the enterpriser, but he or she is not the actual owner or operator, just a figurehead. Is that the case?
Yes.
Right. So if we have the idea that you guys are using in Derry and maybe some other places as well, where you have the oversight is done by OPLC and they are looking for therapeutic massage establishments. They have the right to enter such establishments, don't they? Automatically, they don't have to They can come, unlike the police that have to have some kind of cause, some kind of victim. The OPLC inspector is looking for massage therapy, therapeutic massage establishments. They have the right to go in and look for people who are licensed, and if they see people residing there, inadequate facilities for living, for cooking, for toileting, and so forth and so on, and no licensed practitioners, can't they shut the place down immediately administratively?
I think you're absolutely correct, but I would defer to the OPLC to answer that. Perhaps not. I would defer to the OPLC to answer that question, though. Directly.
But I mean, I think that's the scheme, if you will,
Yes.
of 1469.
Yes, we're not looking to make 1459 or 58, I'm sorry, or 1469.
1469 is the one submitted by
Okay.
Representative.
We're not
Hood.
looking to make that a law enforcement first bill. This is regulation by the state.
Exactly, and I think that's the genius of it, is that it's a perfectly legitimate inspection of an establishment where they can go in a situation where you can't go in without a claim from a victim.
Yes, that's correct. That's accurate.
Okay, thank you.
Thank you. I'm still just trying to wrap my head around the fact that human trafficking, when you have people who are either held against their will or moved somewhere against their will, that there's no way to prosecute somebody for human trafficking after they've moved that trafficked victim to a different location or changed out who's there. And how could we provide that tool?
Well, the problems we face are that, as I stated in my opening, we don't have any victims. They're reluctant to report to us for fear of retribution to either them or their families back in their home country, or perhaps back their families in New York. They have a great fear, so they keep their mouths closed and they don't report their victim status to us.
Yes.
That's troubling.
And that's absolutely one of the challenges too. But when you have people whose entire business model is around victimizing people so much that they're afraid to go to police or go for help, they're very good at avoiding all of the specific areas. But the idea of having more of an overarching one of the human trafficking, where you have where they're moving past each victim, and so that they're able to be not have anybody there who could testify. And if they're operating a facility, but they can't actually produce any of the people that are supposedly working in this facility or have to work for them, and if they've basically been employing people with no trace, no information, how can we make that something so that there's an ability to have a felony stick on somebody who's doing this and break this business model?
I think the only way we're going to do it is to start with regulation, honestly. We've got to start regulating these businesses so they don't keep popping up and coming into our community. Now, they're moving their victims. I'll call them victims because I believe they are. They're moving their victims from location to location, state to state, every 7-10 days. So these folks that are offering these illicit massage services, they're not there very long. So that's by design, by the syndicate operation. That's by design. It makes it very difficult to prosecute.
Representative Gerda?
So I just want to remind the chair, I'm sure she's familiar with this, that people who are in domestic violence situations are often reluctant as well. So that this victim behavior is not only for this.
Oh, no.
I mean, there are marriages in which women are abused and relationships where women are abused, and they don't come out and say it. Even if someone were to point it out to them, they need to be the ones to testify on their own behalf. And maybe we would do that, right? But I find that people who are victims themselves are very hesitant to do that, almost in any situation. And many of these people who are being trafficked don't speak English and are sort of they're totally on their own. right? They have no means of transportation. They have nothing.
And in their culture, police might not always be the good guys, which is another reason they don't come forward.
I'm just trying to figure out how we can provide tools that can work in the environment where victims are unwilling to come forward, because in other states that have facilities licensing, this still happens, correct?
I'm not, I would imagine it does. It's illegal criminal activity that happens all over the country.
And is it still considered illicit massage when they have a massage license?
Depends on the services offered, yes. So if they're offering sex for money, that's an illicit function.
Okay. But any shoulder massages that are just shoulders are within that part. It's just a matter of which services with what kind.
Which service is offered?
Representative DeRoy?
I hate to use the word because it's so controversial right now. But isn't this what ICE is for? To be able to save those individuals who are here, not with their own free will, but they've actually been brought here to be used as sex traffickers. And
Well,
these women probably are.
Thank you. I'm not so sure it's ICE as much as Homeland Security investigators or some other federal and a task force model. Yes.
Thank you.
Thank you. And as far as your interactions with the federal level, is that something where there's an ongoing ebb and flow of information and conversation, or is that something that's more managed through the coalitions and other groups that you have? The task
I'll
forces
speak
and such?
personally from Derry's experience recently. Last year, we formed kind of a task force model, state, local, and federal law enforcement agencies, and we began some enforcement campaigns on these locations, and that was a partnership between all three entities.
Thank you. And don't answer this if you shouldn't answer this, but when you were pursuing it, were there people also pursuing federal charges, considering that there was the interstate transportation and such of people? And if you shouldn't answer that, then don't answer it.
Well, I feel comfortable saying that no information developed that would have led to federal charges.
Thank you. Representative Sellers?
Thank you, Madam Chair. So what I'm hearing from you, sir, is instead of prosecuting, which is almost impossible to do because there's no victim, they won't come forward or whatnot, or they're moved around, it would be better that we regulate this to the point of the state can go in and inspect in a blink of an eye, and if find something wrong, they could bring you in.
I think that these businesses operate and best in an environment where there is no enforcement of any type. That's why it's so important we begin with the regulation at the state level. When we get that regulation at the state level, then perhaps that could, lead to other prosecutions down the road.
Thank you. Are there other questions from the committee? Representative Schmidt?
Thank you, Madam Chair. But is it not the case that if we pass this bill or something similar to it, that the OPLC inspector can go up to the establishment door and require entry because they have that authority to inspect massage establishments? When they get in, they find it's not a massage establishment. They have no licensed massage therapists. They're not providing therapeutic massage. They have people living in the establishment and with inadequate facilities and things that are not permitted by our health and sanitary laws. You can't live in your business, right? And when they can, and then they can shut that place down. And to the degree they shut it down, that business goes away from that location, and you regulate them out of business. And stopping the syndicate is very difficult because, as I understand it, it's largely mainland Chinese. So it's very really hard for an American to walk in and pretend to be a mainland Chinese, an American, an ethnic white person or black person or whatever, not a Chinese person. It's a closed society, is it not?
It is. Your comments are 100% accurate in my experience, but the fact that that OPLC representative can enter that establishment and make some observations that might lead to some local code enforcement operation. Now, honestly, we walk in, we know of these places where they have a hot plate and a couple of mattresses on the floor. And these employees that, I'll call them employees, never leave the building. They're inside servicing customers, and then they're sleeping on the floor with their hot plate. And they live there for days and days, and they're shipped out 10 days later.
And that inspector can shut that place down, can they
Correct.
not?
Yes,
And
so that
bang,
would be,
they are out
that
of
would be code
business.
enforcement and then perhaps fire code violations at that
Yeah.
point.
Right? You can't do that.
Thank
No,
you.
I can't do that.
Thank you. And as far as the laws around the inspection of those, we'd need to look and see what we were planning to put into law around the inspections, because the broad inspection authority under 310 requires notice. It's not just a walk straight in. This is one that is a general one to look at their licensing, look at that information. It's not a immediate, we're walking right through the door spot inspection. That would be a change in practice that probably also would bring additional employees in as well. Sorry, Representative Grota?
Yes, I do want to just make sure, though, that if there's a complaint, it does trigger an investigation. So if someone were to complain, then that would not be, it wouldn't be a visit that's scheduled.
Today, there's currently the ability for the complaints. It's probably just a matter of what time they get in. This is actually in that part that I printed out from the rules, from the existing laws. Thank you. Are there other questions for Chief Fioli? Thank you very much.
Thank you, Madam Chair.
I know that we're having the commission meeting in 8 minutes. I'm not sure if there's anybody else who had something that they wanted to bring specifically to this group. Do we want to, do you all want to stick around more? Obviously, stay with the commission and talk with the members of the commission. I think would be helpful to ask any questions that you have of them, since we're bringing in some of the people who've been working on this and have this knowledge base. And is there interest in continuing the work session after the commission?
I'm here.
Okay. Okay. Is interest in continuing after the commission? You'll need to go? Okay. Perfect. And we do have work session on this noticed on Wednesday, because as early bills, we have until a week from Wednesday to have a final result. So, thank you. And with that, we will recess this work session until immediately following the commission meeting. that we recessed earlier. Seeing that the commission ran for quite a while and we don't have very many people left, I will thank everybody who stayed with us, and we'll be next meeting at 10 o'clock on Wednesday morning for our notice bills. Thank you.